Hello, my name is Frank Congilose, and welcome to the Institute of Responsible Wealth. Our guest today is Michael Canarick of Canarick Canarick. He is a tax attorney. His specialty are wills and trusts, estate planning, and it's been an interesting time over the last few years. There's been a lot of question with regard to the laws, what's going on, and the focus has predominantly been on the tax laws and whether there's going to be a tax, not a tax, or whatever. But in speaking with Michael, it appears that there's a lot more about estate planning and what people should be considering than just being concerned about taxes. So, Mike, why don't we start maybe just give an overview as to what should an estate plan be about and what's the intent of it and how are you seeing it from your end?
Yeah, thanks, Frank. Estate planning, as you mentioned, there's definitely a tax piece to estate planning, but there's a lot of other pieces to estate planning that couples don't consider a lot of times when they go into the process. Control is one issue. It's particularly important where there's children from different marriages, maybe, and the first spouse to die wants to make sure that their child from a previous marriage is ultimately protected. There's creditor protection issues. Maybe when you leave assets to your spouse, is there a concern that maybe the spouse is going to get remarried and divorced, and half the assets end up going to the next divorced spouse and not ultimately with the children? There's ways to protect that.
That's an interesting one in today's society. I mean, we're dealing with a 50% divorce rate. So, the intent of, that whole issue of divorce, of the possibility of that, when you say that, it's like people don't think about it at the time, and it's one of those you're hoping that it's forever, but it's one of those if it doesn't always occur that way, and it just makes sense in what you just said there.
Yeah, and it's not only if the spouse gets remarried and divorced, it's potentially the children getting divorced. You might leave an inheritance to a child or to your children, and all of a sudden, they're married, they're divorced, and half the inheritance that you left for that child ends up with a divorced spouse. There are mechanisms to protect against that occurring. You can assure that assets that you leave to a child ultimately end up in the hands of your grandchildren instead of to that child's spouse, especially if there's a divorce.
One of the things that I find interesting, and I don't know how often you're seeing it, but over the last several years, technology has made it where people to the internet or LegalZoom or all different types of things, or they'll go to a stationery store and they'll get these estate planning kits or whatever. And some people think that they're fine. When we look at them for clients, we think that that they're not inclusive. What's your take on that?
I think it's a huge mistake. I really do. When you do that, you're not having these conversations with attorneys that are expert in this field. No one's bringing to your attention, hey, what about the possibility of a child getting divorced? What about these tax issues? These forms don't really have a grasp of the tax issues, and as you mentioned earlier, they change all the time, and I think you need that relationship with an attorney to explain how they work, update you when changes are made. I just think it's a big mistake. I sit down with clients all the time, and our initial meetings generally run for an hour and a half. And by the time our meetings are done, I've probably brought to their attention 5 or 6 things that they did not anticipate was coming out of the meeting when it started. So, I think that will all get lost, if you do not sit down with a qualified attorney to discuss and draft the documents. I think it's a big mistake.
You had an interesting word when you said that, which is a qualified attorney, because there are a lot of attorneys out there. We know it's not that we don't have anything against attorneys. We think that they're great knowledge base. They have a lot of information, but the area of estates and wills planning and so forth. My experience has been it is different. It's not typical.
Yes, it's certainly a specialty. There's a lot of tax knowledge that goes into the planning. I mean, I'll review wills that clients have in place that were done by a non-tax attorney or a non-estate planning attorney, and without fail, they're missing important tax language. I mean, we're talking potentially millions of dollars of taxation that gets lost. We'll see wills where you know, the kids inherit the money, and as long as they're 18 or 21, they get full control of everything. And you know, again, I think through a discussion, most clients, after we're done talking, think, yeah, well, that's a big mistake. I don't want my 18-year-old to come into an inheritance. I want to see that money held in a trust for that child's benefit, where a trustee can make a decision as to when that child should see some money, you know, paying for college, paying for a first house, buying a car. Those are all legitimate expenses for a child to use an inheritance on, and that could be done through a trustee, but we don't want to give a child control maybe until an older age. And of course, clients will vary on what age they think is old enough, but very rarely do I hear a client saying, I think 18 is old enough, or I think 21 is old enough. And you know, that's the type of language you get from a form document and without having a conversation with an attorney. So yeah, again, I think it's important that you speak with someone that does this.
And you know, in listening a little bit to you, Mike, as you're going through that, you know, one of the things that, you know, hits me is like, you know, you always hear the stories about, you know, people that hit the lottery only to find out that, you know, 5 years later they're broke again, or a professional athlete or someone like that who had a lot of money and in a short period of time after retirement they're broke. And what the issues really are about is control and learning to manage finances.
That's right.
Which is with a simple document that sometimes people might just get or they print somewhere, it might not provide for management.
That's
and
right.
My guess is in some of the documents that can be drafted and so forth, and I know that the work that we've seen with you over the years is that the management issue of assets and what occurs is all a part of what the consideration of how, you know, people and assets are taken care of. So maybe you can just take a couple of minutes and explain a little bit about how that works.
Absolutely, and of course there's many ways to go on all these things, and all of these conversations should be had with a client. You know, from simple things like not giving a child control over his or her inheritance all in one shot. You know, you mentioned the lottery winner situation, and I think another, you know, maybe a problem here with clients, which needs to be pointed out to them, is clients don't feel necessarily that they might be wealthy, or you know, they're not millionaires, and they feel like, oh, something happens to me, you know, they're not getting that much, and they're not factoring in a lot of things. They're not factoring in, you know, maybe the value of their retirement plans, or the fact that they have a couple $1 million of life insurance on their lives, or that their home is worth $500,000–600,000. I mean, you have these people that feel like, all right, well, I got, you know, $100,000 in the bank, and that's what I'm leaving behind, when in fact, actually, you know, you're leaving $4 million behind because you're failing to account for all these assets. And then when we counsel clients, we say, listen, you know, do you want your child to inherit $4 million all in one lump sum? And that's the you know, the lottery point that you just made. It tends to lead to problems. So there's the suggestion, you know, maybe we give a piece at 25, and then another piece at 30, and another piece at 35, or whatever ages, you know, the client deems appropriate. You know, as far as management goes, I mean, there's clients that want corporate trustees, you know, in charge of the inheritance for the child's lifetime. You know, I'm working with a case now where that's exactly the case. There's a lot of money involved, and you know, rather than give the child control over everything, there's a corporate trustee that's going to be in place, and it's going to last forever. And again, by doing that structure, you're touching upon some of those issues we talked about previously, where if there's a divorce with that child, that's going to be protected from creditors. At that child's death, that money's going down to the grandchildren, potentially tax-free to the grandchildren. So yeah, management and control and all these decisions are very important.
Very good.